Any mention?
May it please your Lordships? Lordship, I beg to mention item number 14 to 16. These are connected matters. I'm appearing for the respondent number 4. I pray that this matter may kindly be taken up after 3 weeks.
And for the petitioner, ma'am.
No objection.
No objection.
Yes, 3 weeks. The request made by Dr. Kural, appearing on behalf of the respondent number
4.
4.
And for the state respondent.
Yes,
Obliged, Lordship.
3 weeks. Huh?
May please Lordship.
Yes.
Lordship, I beg to mention item number 12, my lord. I have informed to the government as well as to the private respondent. They are here, Lordship. This matter may come after 2 weeks, Lordship.
No objection, Your Lordship.
23, 2 weeks at the request of the petitioner. Yes.
Much obliged.
Much
Lord.
less, Lordship.
Are you listening? Yes, my lord. I'm mentioning item number 9, my lord. I need a little time to construct the copies that I have to service the other side. Also because there's an order from Justice Thankyu's court with regards to forming a committee. I need to put all those orders together. If you give me just a week's time.
Which item you are mentioning?
Item number 9, my lord.
Yes.
A week's time.
Oh, this is that.
Shetty Commission matter.
Yes. Okay, 1 week. The request made on behalf. So it's okay.
There's only an order here
You
which says
for
for the
respondent
state.
number?
For the state.
See, I beg to mention item number 11, Lordship. This is a criminal appeal. I am for the state house.
Yes.
So 2 weeks, Lordship.
Yes. No problem. That's on the request made on behalf of the state respondents. Let's this matter after 2 weeks. Yes.
Obliged. May I please, Lordship? I beg to mention item number 7, Lordship. I am appearing on behalf of A. Khan, Lordship.
Yes.
May this matter take after 2 weeks, Lordship.
Why 2 weeks? Yes.
I appear on behalf of the private respondent.
But the state?
My lord.
No objection.
No objection.
As paid for by the learned counsel of the petitioner, not objected to by the learned counsel appearing of the respondents. List after 2 weeks. Yes.
Much obliged, Lordship.
Please, Lordship, I beg to make a mention about item number 32, Lordship. Item number 32. Lordship, I pray the matter may come up after 3 weeks, Lordship.
No objection.
32. The request made on the respondents. You are appearing for respondents?
Only one respondent.
Only one.
Sole respondent.
List after 2 weeks. Yes. 32.
Obliged, Lordship.
Please, Lordship. Please, Lordship, I beg to mention item number 17. I have already informed to the petitioner, so this matter may come up after 2
Yeah.
weeks.
Mentioning on behalf of
Behalf of Saiful Ali, respondent number 4.
respondent number?
Respondent number 4. Item number 17.
No one is for the petitioner.
I have already informed, my Lordship.
Also, the request made on the number 7, sir. List after 2 weeks. Yes.
Leave.
Item number 1.
May I please, Lords?
Yes.
This matter actually pertains to the Meghalaya, it's MIDC, Industrial Development Corporation. Now, this issue relates to the admitted position is that the employees of MIDC, they are not entitled to any pension or other benefits. Earlier, they were getting the commuted leave and some benefits. Now, on 14/10/2024, a decision was taken by the Board of Directors of MIDC to also withdraw that benefit without any reference to the employees who are the beneficiaries of that benefit. That is under challenge before Lordships. I'll take your Lordships to page 101, my lords. That's the impugned order.
Who are you? You are a retired person? You all are pension.
No, my lords. Some of them are serving first writ petition. They are serving, my lords. Item number 2, one of them has retired, my lords. He is also before your lordships. If my lords kindly have a look at annexure 5, page 101, my lords.
Yes.
It says this is to notify to all employees of the corporation that the board of, my lords have it.
Yes.
This is dated the 4th of October 2024. This is to notify to all employees of the corporation that the board of directors during its 237th meeting held on 30th September 2024, after careful examination of the facts and objections raised from time to time by the Office of the Accountant General Audit, Shillong, and the Committee on Public Undertaking, Meghalaya Legislative Assembly has decided that the policy, practice of staff retirement benefits and additional retirement benefits and encashment of commuted leave shall be discontinued by the corporation with immediate effect. So these were, my lords, benefits that were already there accrued upon the employees at the time when they had joined the service.
By virtue of certain policy, not because of some rule or.
Statutorily, my lords, the rules do not provide for it. That I must admit before your lordships. At this stage,
What is the nature of objection raised by the Accountant General?
my lords, we are not privy to that.
Who will issue notice then?
At this stage, I'm only praying for that.
They have not withdrawn any statutory benefit.
No, we've said, my lords,
It's a kind of a policy which was in existence and they have discontinued.
they have discontinued that. What we're saying is, my lords, at least they should have, these are benefits, my lords, which are there upon employees who have probably put in 25, 30 years. One fine day, my lords, is just taken away. And otherwise also, they don't have any pensionary benefits.
Yes, Mr. Sivan.
My lord, I'm entering appearance for respondent number 1, 2 and 3, my lord. We will need instruction also.
Oh, there are other respondents also.
My lords, 4 to 12, my lords, 4 to 10 would be, no, I'm sorry, my lords. 4 to 8 would be, my lords, the MIDC. 9 is the Accountant General, my lords. 9, 10 is Accountant General. 9, 10, 11 Accountant General, and 12 is the Committee on Public Undertaking.
The Accountant General is appearing.
So you will accept notice on behalf of the Accountant General. Are you entitled to accept notice? Are you? Okay. So you'll have to take steps for the rest of the.
My lords.
Okay. Heard Mr. Kapil, London Senior Counsel, assisted by so and so. Issue notice, returnable in 3 weeks. Mr. Shinkan, London GA here.
My lord.
London GA appears for the respondent number
1, 2 and 3, my lord.
1, 2, and 3. Then you say MS. Give your name, please. Appears for the respondent number 9, 10, 11. Step. Say petitioner shall take steps for service of notice upon the respondent number
4 to 8 and 12, my lords.
4 to 8 and 12 within 2 days. List after 3 weeks. Yes.
Next matter, my lord,
Item number
connected.
Same.
Same matter.
Same matter.
Different petitioners.
Different petitioner, he retired, my lords. That's the only
Item number 2, there is only one petition.
one petitioner. Oh, I'm sorry, my lords, 2 petitioners.
Both are retired.
My lords.
Item number 3.
Obliged.
Yes, Mr.
Please, Lordship. Lordship, this is regarding the non-release of the pension. I was working as a peon, as a regular service, retired in the year of 2021. Now they sent that state respondent, deputy commissioner in the office, they have lost this service, my pension, that service book. So there was actually a request from the department itself to reconstruct my service book and to release the pension and some other things.
When did you retire? Which year?
On 30 November 2021, Lordship, which is there in the annexure 4.
Till now, nothing has been, no benefit has been
Lordship.
given to you. No benefit was
No.
disbursed to you. Yes.
Till now.
Yes, my lord, this is really sad to hear this.
Just take instruction and just see if it is pensionary benefits.
We
You should not withhold it without any reason.
Why not? We can also dispose of this matter here and here by with the direction saying that, in a time-bound manner, so and so can be
No,
constructed.
but let us you verify whether it has been released or not. It may happen like that it has been released and The petitioner doesn't.
Oh, we'll confirm.
So that is
Yes,
proper
we'll
to take
confirm.
instruction. Yes.
I'll call respondent number 5, Lordship.
Yes.
Seek instruction, Your Lordship.
Okay. Same like hard, Mr. Petisoma. You should notice. Return over in 3 weeks. MS Bang and so having Bang appears for the respondent number 1, 2, 3, and 4.
Yes.
MS so and so appears for the number 5. And hence no further notice is called for. Step the learned counsel for the respondents shall take necessary instruction. Step list after 3 weeks.
I will do rest, my lord.
Item number 4.
Please, Your Lordship. Lordship, in this matter, I'm seeking for some accommodation, Your Lordship, on behalf of Mrs. Thapa, Your Lordship. Lordship, please.
Lordship, this matter is pending for the statutory obligation, Lordship.
Lordship.
Well, Lordship has already granted them ample opportunity to come up with instruction whether they want to proceed with this matter or want to, Lordship will take the.
There is availability of alternative remedy. Yes.
Lordship, if the
This is
statutory.
one thing you see, like just you keep on asking time without doing anything. This is something
Apologize, Your Lordship.
this court does not approve those kind of things. You see, every time you have some situation where you need to take some instruction or all, you just keep on taking time repeatedly again and again.
Lordship,
not
the
something very good.
statutory obligation is very clear, Lordship, here. You have to.
Lordship, difficulty is Mrs. Thapa is leading this matter.
No, it's, you if you want to do, you do it. Otherwise, just
Lordship.
we will dismiss it. Yes.
Lordship, it may be recorded that I am
Yes.
objecting in this.
Yes. Yes. Just say, Mr. So and so learned counsel append for the petitioner. Praise for grant of adjournment on the ground of non-availability of Mr. Thapa, the arguing counsel appearing for the petitioner. The prayer has been opposed by MSP Bhattacharya, learned counsel appearing for the respondents. You are appearing for all the respondents.
All the respondents.
Yes, sir. However, warrants of justice, the matter is urgent. List after 2 weeks. Yes.
Item number 8.
Lordship, I have similar prayer, Lordship, in this matter also.
Who is there for the respondent here?
For the corporation, Your Lordship.
None appears for the respondent. On request made on behalf of the petitioner, list is matter after 2 weeks. Yes.
Item number 10.
Yes.
Lordship, here I have to come up with the instruction, Lordship. Lordship, I have the instruction the matter, the order may be quashed. But Lordship, only one aspect, Lordship, just for the year 97, Lordship. I'll just draw Lordship attention with respect to 97 only, Lordship. Rest, it may be quashed and set as
No, we cannot quash it partly. If you see,
Lordship, only with respect to.
what is the problem with 97?
Like 97, I'll draw Lordship attention to annexure 1 is 23, Lordship, page number 23.
Yes.
Lordship, here in the matter of enquiry proceeding under section 7A, it is written, Lordship.
Yes.
Now, Lordship, according to 7A, order is passed in page 26, the operative part of the order, Lordship. Operative part of the order is page 26, Lordship.
Yes.
Now, in the balance due column, Lordship, the first amount, Lordship, is 440 and the balanced amount is 608.
Yes.
Lordship. Now the order is passed on 1st January 2014, 2004, Lordship.
Yes.
Now, Lordship, I'll draw Lordship attention to the annexure, page number 72, Lordship.
Yes.
First column, account 1, Lordship.
Yes.
Account 1, Lordship. The same amount, Lordship. Amount is same, Lordship.
608018.
608001, and in also account number, account 1, Lordship, 440047, Lordship.
Yes.
So this amount is not pertaining to wage month, Lordship. This amount pertains to 7A assessment, Lordship. They deposited it.
The earlier judgment was with regard to what?
14B7Q, challenging 14B7Q. It is not challenging about 7A assessment, Lordship.
You should have clarified it in your order.
Lordship,
That is not done.
That was a
Just a minute,
mistake committed, Lordship.
Your department's thing, you see, like they should have specifically provided it. Just a minute. The High Court's order, earlier order, where is that?
Page number 65, Lordship. Page number 64, 65 combining, Lordship. High Court order is. It is challenging about 14B7Q in the second.
Yes.
Second para, it is already mentioned, Lordship, that the payment of damage interest under section 7Q 14B of the EPF Act, Lordship. It is not a challenge under 7A, Lordship.
Okay, now the present notice which is under
14B7Q, present
Challenge?
order, but it is the present order is passed.
the impugned order. Yes.
Impugned order.
Where is that?
Impugned order is page number 84, Lordship. page number 84. Further, Lordship, in page number 82, Lordship, in para 2 we have already cleared, Lordship.
No, what is under challenge? 84, yes.
84 is under challenge,
Yes.
but daily order, which is passed in page
See, this
82.
is says specifically says about 14B7Q, isn't it?
Yes, Lordship, 14B7.
So there is no reference of 7A here.
No, Lordship, there is no reference of 7A. But 7A referred we in page 82, Lordship. In page 82, Lordship.
What is page 82?
Page 82 is daily order, Lordship.
Is it under challenge here?
No, Lordship, it is not under challenge.
Then?
But we have already reflected that.
No, see, your whatever order is passed, that will basically will be with regard to that 14Q and 7, 14B and 7Q.
Yeah, Lordship.
This is not 7A. This liberty will be there with you.
So if
We
there
will
is,
just say that whatever is covered by the order of earlier order of this court, that should not be reopened.
that should,
Now, if according to you, if you say that earlier order is not with regard to order passed under 7A, that situation will remain open to you. You will not make any specific observation yet.
Lordship,
Okay.
Lordship, the 7A under 7, whatever the challenged under 7A, Lordship, since 7A is not challenged, Lordship, so it may be a case that when it comes to our
That is for you to decide. This court will not give you any advice or opinion on that. You do it.
Lordship.
Okay. Okay. Now, what we understand from the perusal of the impugn order is that is under 14B and 7Q.
Lordship,
7 has not been referred anywhere.
Lordship.
Okay. Now, the earlier round of earlier order passed by this court, that is also with regard to
14B, 7Q.
Yes. So 7A
No
will
one,
remain
no
open.
one has challenged 7A also, Lordship. Neither it was challenged before this honorable court in
That is
earlier
okay.
round.
That is you take of this thing, note of those things, and then do the things accordingly.
Lordship, the liberty may be given that we under 7A assessment, whatever comes under 7A assessment,
That is for you. See why you need liberty from this court. If you say
Lordship,
liberty, then court will acknowledge that you have a claim under 7A. But then the thing is that we will mention that it is only with regard to 14B and 7Q, and that will take care of the situation. What else is needed?
Lordship.
Where is the summon?
Summon is at page number
Page 70.
page 70, annexure 10, Lordship.
Page, just a minute. How many pages this summon?
Summon is of 2-page, Lordship. But 2-page summon, it is annexure A along with the summon, Lordship.
There,
Annexure A is along with the summon, Lordship.
This is dated 2/12 or 15/12? 15/12.
1512, Lordship.
And the order is dated 2/11/2022.
Lordship.
And what is that page 65, which you referred to earlier?
Page 65 is the 7A assessment, Lordship.
No, but then which way it is relatable to this thing?
Lordship, under 7A assessment, we bring the any institution under EPF, Lordship. When the 7A is assessed, the institutions comes under
Oh,
EPF.
sorry, it's page 72, I think.
Page
No, not page 72. Just a minute.
page 65 is the judgment, Lordship.
No, no, that's page 23. Page 23.
Page 23 is the 7A assessment, Lordship.
And that is not under challenge, isn't it?
No, Lordship. Never under challenge, Lordship.
Now you want to say that the claim made in page 23 should remain intact. That should be, you see, like you should have
Yes.
the liberty
Yes,
to do
Lordship. It should have. It is to
that. Since it is under 7A
Lordship.
and not covered by the earlier order of the...
Lordship. Earlier order of this Honorable Court.
Yes, Mr. Shen?
My lord, so far this page 23, Annexure 1, my lord, these are all concluded, amount has been paid. This is nothing. This is only as by way of introduction, my lord, I have just placed it. So this is no way relevant so far, my lord.
No, but then what about the order of the High Court in the earlier round of thing? That
Yes,
does
my
it
lord.
take into consideration that 7A?
My lord.
Come to page 65.
I'm coming. That is clearly related to the same period, my lord. Lordship will see, my lord, this is not relating to the page 23. Page 23 was not under challenge in this. Because page 23 is something else, my lord, which we have satisfied, amount paid, everything done. This is some other notice.
Anyway, if they say, supposing if you say
Lordship.
that page 23 stands satisfied, in such a case, if they make any fresh claim,
My lord,
then definitely...
no, but there is some confusion it has been created here, all lordship. So for page 23 is concerned, my lord, amount has been assessed, money has been paid.
So nothing,
This is-
nothing.
this is-
So at least no proceeding is pending against
No,
you.
no, no.
So far as 7
this
is
is,
concerned.
this is not an issue here at all. What is the issue, my lord? I can take my lord. I think that will
So
clarify
that means
what is there before the single
just a
judge.
minute, just a minute, just a minute.
Lordship.
Just let us finish.
Lordship.
Just bear with the court. Just
Lordship.
because this is a new subject for the court. This
Yes,
may
sir.
be a new thing for you.
Sorry.
Now you see, like this 7A. So far as the amount shown in 7(8), page 23 is concerned.
Lordship.
So that has no bearing with the view of the things.
Not at all, my
This is totally separate.
My lord, for the satisfaction of this case, my lord, what single judge has decided, let me clarify, my lord. Lordship, if I can take my lord to page 56.
Just a minute.
56, my lord.
Just a second. Yes.
Lordship has got it, my lord.
Yes.
Yes. Now, my lord, this is the assessment made. What is under challenge, my lord? This is the assessment made, my lord. The type copy your lordship will get. Page 59, my lord. The
Yes, you referred it on the other day.
lordship.
March 1988 to June 2001.
Yes. Now, your lordship, following this assessment, demand notice was issued at page 62. Page 62, my lord.
That is, but then that is reflected in the order itself. You do
Yes,
not
my
have
lord.
to
So
take-
this is what is under challenge. What my learned friend is referring to,
Yes.
page 23. This is no bearing. This is not an issue. This I have just by way of introduction, just to show that I am very diligent. Time to time, whenever the proceeding was held, I complied with it. Only for that. I don't know how this comes, my lord. Remotely, also not concerned with this case.
Lordship, the amount, Lordship, I already showed to Lordship. The amount, had there been anything, it is exactly the same amount, Lordship. Not even 1 rupee more, 1
This
rupee
is
less.
why we are concerned
Exactly
with
the
that,
same
yes.
amount what has been assessed by
That
the
is at
7.
page, where is that page?
The demand notice.
No, just a minute.
Page number 26, Lordship.
Which you referred to earlier the amount. No,
Lordship.
not the 26. And then later part, where you showed? 26 is the
26 is the 7A amount and later 72, page number 72, Lordship. Annexure A, Lordship, page number 72.
yes. That is what? What is this?
This is account 1 payment is,
No, it starts from which page? It is a continuation of which page?
it is continuation of the
Annexure 10. Page
Annexure
70,
10.
isn't it?
Yes, Lordship. It is a continuation of Annexure 10, but it is,
So your submission is basically because of the similarity of the amount which is mentioned here.
yes, Lordship. Lordship, for a mere understanding, Lordship. What the damage, the amount is deposited on the number of employees, Lordship. For just mere understanding, Lordship. Amount is deposited on number of employees, Lordship. Can it be possible, Lordship, by any means, 4 lakhs 47 rupees? Can it be any possible way? Can a employer will deposit in the name of employee, Lordship? 6 lakhs 8,018 Lordship. Can it any be possible, Lordship? Unless and until it is under 7A, Lordship. Assessed
No, but then
amount.
it shows amount remitted, isn't it?
Lordship.
But see, amount of 7Q12 video. Just see.
7Q14B, but it is
7Q14B.
the employer's responsibility to deposit in the same.
No, that is okay. But then what is 7A? Just what is 7A?
7A is, Lordship, determination of money dues from employees.
Just a minute. Yes, 7A.
Yes, Lordship. May I? Determination of money dues from employers. The Central Provident Fund Commissioner and any additional additional Central Provident Fund Commissioner, any Deputy Provident Fund Commissioner, any Regional Provident Fund Commissioner, or any Assistant Provident Fund Commissioner may, by order, in case where a dispute arises regarding the applicability of this Act to an establishment, decide such dispute and determine the amount due from any employer under any provision of this Act, the scheme, or the pension scheme, or the insurance scheme, as the case may be, and for any of the aforesaid purpose may conduct such enquiry as he may deem necessary. The officer conducting the inquiry under subsection 1 shall, for the purpose of such enquiry, have the same power as are vested in a court under the Code of Civil Procedure 1908, 5 of 1908.
You can skip this sub clause 2, then come to where is the relevant out? Where we,
The
7A basically takes into
determining the
consideration
amount to assess.
about determination of amount due from an employee.
Yes, Lordship.
Now it can be on many accounts, isn't it? It's like a
Pension account is
due under the act or the scheme
Lordship.
or the insurance scheme.
Lordship. Pension scheme, including the
Okay.
pension
So
scheme.
7A basically is for determination of whatever amount is due.
Lordship.
Yes. And what is this 7B and
Not 7B, Lordship. 7B is review.
7Q and 14B?
7Q, 14B. 7Q is the interest, Lordship. Subsequently, interest payable by the employer.
Okay, 7Q is interest, 14B is damage.
Damage. Lordship.
So everything is basically dependent on the determination under 7A.
7.
So it is not that there are separate provision for recovery of different amount.
Lordship, 7A, here what happened, Lordship? Here they have deposited the 7A amount as a 7Q 14B, Lordship.
See,
It is
even
not
even
the case of 14B, 7.
that is what, say, supposing if any claim is made under 7Q or 14B also, but then that has, is it a determination under 7A? Is
No,
it not
Lordship. No, Lordship. Determination, what happens, Lordship? Suppose an employer is having 20 employees, Lordship. Now, initially, we issue notice to the employer that you come under EPF, and for the time they have not paid EPF, we assess the amount that this is the amount to be paid,
Okay.
lump sum. So,
this much is the employee, this much should be a deduction, and that much should be a deposit.
yes, Lordship. So,
Now, see, the determination means it is the determination of the principal amount, not the amount which comes under 7Q and 14B. Now, which way 7Q and 14B is this thing assessed?
Lordship,
What is the best then? Which way you do it?
Lordship, the
Is it by
calculation is
resorting
there.
to the same process as prescribed under 7A sub clause 2?
No, Lordship, the calculation is there in my affidavit, Lordship.
No, who determines in which way? You do not give us the calculation. Just see which authority determines
The EPF
and what is the
determines.
process of determination.
The process of
Is it by the same way under which 7A is determined?
No, Lordship. It is the 7A is determined, Lordship. Now they come under EPF, Lordship. Now they deposit the
Is
20
it done by a
employees.
separate process or it is done by the same process?
No, Lordship. It is a separate.
Yes, Mr.
process.
Sen, just can you
It is a separate process, Lordship.
That issue is coming up again and again, even before the Apex Court. 7Q is not available. All these problems are there. Now, what is 7A? Now, 7A, my lord, say all the dues, any kind of dues. But normally, what is the practice of the Provident Fund? 7A, normally they take recourse. What 7A is ensuring, there should be a fair quasi-judicial proceedings. The parties to be heard.
We can understand. See, Mr. Sen, we are not going into all those things because
Yes,
we have
sir.
seen that thing as for the provision. Okay, because this confirms a judicial, it should be deemed to be a judicial proceeding, 7A.
Yes, ma'am.
So we have seen that. You see, there is no confusion with regard to that. What we are trying to understand, of course, see, like you may have like already you understand. You may find that this court is putting a very elementary question.
No.
It is not that. The thing is that what this court has seen, this 7A basically is for the determination of money due from the employer.
Principle.
Now, after it is done, then the question of imposition of interest and damages come, isn't it?
Lordship.
Now, the query of this court is basically that when you determine the interest and the damage, is it come automatic after the determination of 7A is made, or for that you have a separate proceedings?
There has to be.
There is a
Has to be.
separate.
I just read out. That is there.
Lordship,
That is
I'll
why
just
some
bring Lordship to my
7Q
affidavit,
say
Lordship.
cannot be
I'll
conducted.
just
Let us just we'll just try to visit. Just try to
What
let
is
us-
say?
let us
That
go get the
that
basic idea. You see.
basic idea, Lordship,
Wait,
page number.
We'll come to you. We'll come to you. Just
7Q, Lordship. That the question, my lord, comes again and again, your lordship. Now 7A also simultaneously they can decide. When the apex court did 7A, when you are taking recourse, when do we do that? And if you do it under 7A, then even 7Q it becomes a composite order becomes appealable. Otherwise, it's not appealable, creating confusion. Now, if you independently take recourse after collecting the principal, determining the principal, suppose, my lord, in the same proceeding, my lord, interest and damages were not determined, there is no bar. They will have to hold a separate proceeding. And that indication is very clear and categorical in 7Q. They say it without hearing. If I can take my lord, 7Q.
No, probably now this court is entering into arena which will make this matter, disposal of this matter.
7Q, my lord, has got. Lordship has
7Q.
got.
Wait, just a minute.
I'll just take my lord to the proviso.
Just a minute. Let us first find out.
Oh, lordship, sorry.
Yes, deposit of amount due.
No, Lordship, interest payable.
Oh, sorry, the interest payable.
The employer shall liable to pay the simple interest at the rate of 12% per annum at such a higher rate as may be specified in the scheme or amount due from him under this act from the date which amounts will become due till the date of his actual payment, provided that the rate of interest specified in the same shall not exceed the lending rate of the interest charged under the schedule. Now, my lord, I take my lord to 14B. Sorry, 14B.
Now, reading this provision
Lordship.
gives an impression to the court
Lordship.
that the interest is automatic.
Lordship.
Once the amount is determined under 7A, then interest is, you see, like it comes as a,
No.
it's ancillary. You see, like it's a,
Now, what is the rate? Now, rate may vary. It depends on many things.
the rate is so far as the schedule, but the payment of interest. We are not, you see, what should be the rate and what should not be the rate. Normally, court will not go into all those things. Will not venture
So
into.
why I am saying, my lord, there has to be a proceeding. So for determination of the interest, my lord, it again depends on the facts and situation. It can be up to the maximum slab or may not be. Depend. Now your lordship will come to 14B. 14B proviso.
Just a minute. Yes.
Proviso, my lord. Provided that before levying and recovering such damages, the employer shall be given reasonable opportunity of being heard. So there
Damage is something punitive. It's a
punitive.
that is why probably that is there.
My lord. Now, my lord, as on date, my lord, the situation is there can be an independent proceeding only for 7Q. Only for 7Q.
Now, interest is chargeable to what situation?
Delayed payments.
Delayed payments.
Delayed payments.
See, like delay due to any factor.
Any factors.
Say, supposing if an employer fails to deposit in time
Lordship.
because of some reason which is beyond
His control.
his control, then also interest is payable.
Interest, of course, there are certain exemptions. There is an exemption clause, of course, like a Sikh industry, other things. Those exemptions are there. Exemptions are there. So that is why I am saying, my lord, why a proceeding is. Suppose this is not a case, of course. Suppose a industry, a Sikh industry. So then they are entitled for certain exemption. That's why a proceeding is required. So there can be an independent proceeding while on 7A for determination of the principal. Subsequently, there can be a proceeding under 14B also possible, and separately under 7A. All these are possible.
Now the problem is that supposing here, as prayed for by the respondents here, now if they want that yes, we interfere, we send it back again, or give them the liberty, without sending it back, we give them the liberty to do their assessment process from the years which are not covered by the earlier one.
Yes, yes.
Now, but then, if so far as the year of 1997 is concerned,
Lordship.
and the 7A has to be kept open, that
7A.
means the 7A, because according to them, That is 7A assessment. Now that is why this court basically thought
Well, I could
that
disagree.
there are different process for assessing different amount. Different amount means one is the principal, other is interest, and third one is damage. Okay. So now 14B contemplates that if you have to impose damages, then you have to give a reasonable.
But we are in this.
But then charging interest, that is not there. For charging interest,
There has to be
a
a
similar provision has not been contemplated, because probably interest has been not be treated as penalty.
Not a penalty,
Under
but
the-
the proceeding has to be instituted. That's why, my lord, normally.
No, interest is automatic. Say once you are found liable under 7A,
No, sir.
then interest should be automatic.
But there has to be a proceeding. Without proceeding, it can't be.
No, 7A also, there has to be after.
Yes,
Definitely,
after
isn't
it
it?
is dues.
So for interest, you do not have to have a separate process. Now 7A will take care of this thing, 7Q. Is it not the position? Then
My-
make us
my humble
understand the
submission-
law. Then for 7Q, we need a separate proceeding.
Yes, my lord.
Where it is,
It is if it is not done under 7.
where it is contemplated.
Lordship, furthermore, to clear furthermore, Lordship draw attention to para 32 of the EPF scheme, Lordship. Para 32A of EPF scheme. The scheme part, Lordship.
The provision of the scheme can be read into the act. Can it be?
Lordship. The scheme is already.
So if something is not covered by the act, we can say provision 30.
32, para 32A, recovery of damages for default payment in any
Yes.
contribution, Lordship.
Yes.
So now here, Lordship, if the period of default is considered, Lordship, this is after amendment, Lordship. Prior to amendment, there was a change. There is already. It is. I have reflected in my page 10 prior to change, prior to amendment from 2008.
Now this amendment came in 1991.
Yes.
Yes, so it is long-
after 2008. So before 2008, the rate was different. In place of less than 2 months, 5%. So before 2008, it is 17%.
Yes.
Then 2 months, it is 10% here in after amendment. Before amendment, 22%.
That is with regard to the rate, isn't it?
This is the damage
Now, what
rate.
you are trying to point out here, just show us, tell us. Tell us in simple words. Just do not get diverted to here, there. We
No.
are not into the part of interest or damages, what should be the percentage. What we are trying to understand is that whether there should be separate proceeding for 7A, 7Q, and 14B, definitely it says that before imposing damages, you have to give notice. So
Lordship.
it contemplates.
Lordship, there is separate proceeding. That is why 7A order is passed under separate proceeding, and for 14B, 7Q.
What
there
about
is-
7Q?
7Q is on 7Q, 14B together. The proceeding initiates together. That is why the summon is issued together.
It
The
means-
summon- in the
it means-
summon-
It means you want to say 7Q also is punitive.
7Q is interest on damages.
So that is what that comes as penalty, that means. Any decision on that thing, anything which,
Regarding, my lord?
that is, we do not understand the 7Q and 14B. Now 14B is damage.
Lordship.
Well, definitely damage means something like you are penalized for something. You see?
Lordship.
Interest something because of the delayed payment.
Lordship.
Yes. And so far as the language of 7Q is concerned, what understanding this code gets is that once the actual amount is determined, then you have to pay the interest for the delay.
Lordship.
And it is automatic.
I'll try, my lord. I'll try
That
my
is where this code is confused. Until and unless you show it,
No, my
here,
lord, Lordship, going by their own summon, if a proceeding is not required at all, they should not have issued a summon under 7Q.
no, that is
seeking
that
for a
is that
short.
is the
Number
process
one.
they have adopted. But then, how do we assume that whatever they do, that it is done illegally?
Well,
Until
but
and
this-
unless law contemplates. Now 7A you will find
Lordship,
in 7A subclause 2,
Lordship,
it has been provided.
Lordship,
The authority is confirmed with the power of a civil court,
Lordship,
and that includes the power of summoning and attendance of the
Lordship,
party, isn't it?
Lordship.
Now, whether that kind of similar thing for interest, charging interest, it is not needed.
This is there, my lord.
Where is
I'll
it?
just- 7A. No, 7A, what the 7A is? Lordship is very correct. Interest is what, my lord? Delayed payment, one that is there, then you are bound to pay. That becomes a due under the Act. This is by operation of the statute, what my lord is indicating. And you, lordship, will see the language of 7A. 7A is any dues, not only principal. Obviously comes, my lord, interest.
Interest also will be due.
It will be. And normally it should be decided. If you are not doing
That is
it,
why, see, that is why the I do not know. Maybe the court is
no, lordship.
court is not able to communicate it to properly. But the very question which this court put
Right,
finishing is that for determination of interest, do you draw up a separate proceeding? The answer is no. The 7A will take care of 7Q, isn't it? Because that
But
also
if you are not
that also
doing,
is
if you are not
and
doing,
then 14 is separate.
yes, 14A, of course.
14B is
Damages.
separate.
Damages.
So that is why you see, once you are given notice for determination of the principal amount, interest comes automatically once it is determined against you, isn't it?
Exactly, your lordship.
So
But
for
in
that
this-
separate proceeding is not needed.
Not required.
But then for damages, say supposing that some damages has to be imposed the same amount, then there has to be a separate suppose, isn't it?
Exactly.
That is what exactly.
But what is happening, my lord, here? What is happening, my lord? What the Provident Fund is doing, they should normally determine what your lordship say. One, there is a delayed payment, then automatically comes the other due interest in 7A. They are not doing it. If they are not doing it, there is no bar. Then if you take up a proceeding when you want to determine separately, then you will have to initiate proceeding. You will have to take cue from 7A. Because 7A contemplates, my lord, elaborate proceedings. No. That's how, my lord, it comes. In fact, my lord, I don't know, I have a case today. Same issue has come up, my lord, before the Apex. Apex is saying, why don't you do it under 7A? If you do, many problems are solved because 7Q is not appealable.
Okay.
Those
Yes.
problems are there. So, my lord, everything is germane in 7A. So, this is a statutory dues. They should have determined under 7A. They have not. Subsequently, they took up a proceeding and they determined, and that amount, my lord, was reduced at the intervention of the court. I am now only concerned with, my lord, 7Q and 14B up to a particular June 2001. Now, that you could not have reopened. And other issue comes, my lord, suppose it is under 7A, it is a due under 7A. Kindly your lordship will see, my lord, 14C, 7C. Now 7C say, my lord, if any amount escapes for a assessment year, dues, that will include principal, that will include interest also. If it escaped the notice of the authority, then they can recover it by initiating a fresh proceeding under 7C, but within a period of 5 years. There also they are barred. But since your lordships, my lord, want to, because of the judgment, thing has been settled, they should not have
No, see,
reopened.
then effort was made with the respondent to basically to show that the 7A,
Lordship,
the claim under 7A,
lordship.
and the notice or the order which was under challenge in the earlier round of litigation falls into different categories.
No, my lord, no.
That is what.
No.
I mean, that is why the liberty was asked for.
No, my lord.
Now the court was basically trying to determine that.
No, I got it. If necessary, I will take, my lord, again what has been challenged in that writ petition. That writ petition has been challenged determination of 7Q and 14B. Nothing else. They could have done it under 7. It's their job, my lord. They had not done it. So they will have to initiate a fresh proceeding. They initiated a fresh proceeding under 7. I came before the court at the intervention of the court.
For 7Q, whether fresh proceeding is needed.
My lord, if it is not done under 7A, they could have decided it while deciding 7A.
But then if you say 7Q is due,
Lordship.
then again whatever they do fresh proceeding, that will be under 7A only.
Normally, it should be.
It has to be. If
has
you say that is the due.
Yes. This is a due.
Say supposing
Lordship.
if they draw a proceeding,
Lordship.
7A, they determine the principal amount,
Lordship.
they do not charge you interest. Now later on they say no, you have to pay interest also. They make a claim. So they have to again redo the 7A process.
No, no. So this is understood.
Since it was not charged together.
This is to be understood, my lord. This is 7A. It's to be understood. Otherwise, how? Otherwise, how? But if you are saying 7A, then you are statutorily barred. June 2001, 22. Now 7C say any determination under 7A, 7C say, subsequently it comes to your notice, you can reopen it, but within a 5 years, not beyond that. You cannot do it after 12, 13 years. My
Barred
lord.
by limitation.
Barred by limitation. And there is no scope for, my lord, waiver or condonation. So in that way also it is done, my lord.
That way, that
In fact, initially my
even
argument
claim
was
for interest also will be barred. Says
Obviously.
after 5 years. Because there will be, that has to be determined under 7A.
yes. 7A. That do you agree? So what, I'm leaving out the damage, but 7A, going by the statute, what my learned friend is arguing should have been under 7A and all. I also agree, my lord. It should have been under 7A, but they have not done. There is, in every case they are doing it like this. Not only here, across India, my lord. Across, in one case, my lord, Supreme Court has said, why you are not doing under 7A? You should do, because the other
there is a
consequences.
confusion. See, an effort has been made. Come to page 72, please, of your petition. There is an attachment to this summon, very summon.
Yeah, these are the documents they have relied on.
This page 72 of your
No.
petition.
No.
Have you seen the tabulation?
Yes, I have seen.
Now these are the claims, isn't it? These are the amount which they have claimed from you,
Lordship.
isn't it?
Lordship.
Now at the very top, 10, 1997.
Which month? 97.
See, 15/11/97 to so and so 2004, isn't it?
Lordship.
Now this amount, according to the learned counsel here,
Which amount, my lord?
this amount which is shown on the right hand side,
amount.
right hand column.
Lordship.
See, 7285 7Q, 7285 14 we have seen. There are two on the first column of the tabulation,
Lordship.
isn't it? You have seen.
I've seen, my lord.
Now account number 1 gives you 440047
Lordship.
and the last total is 6080187.
Lordship.
Now the contention of the learned counsel for the respondent is that is a determination under 6A.
7A.
7A.
Oh, sorry, 7A.
Okay.
Now
My lord.
the amount is under 14B.
Lordship. Now, my lord, here the determination, here, my lord, how they are calculating the interest, my lord, damage also will come. The number of days.
No, we do not want the basis of company. Now what we are
No, it is mentioned
basically
there. If your lordship comes, delay days 7Q 14B. Lordship will, my lord, first. This is for the challan for which month 1097. Next column, they have taken into account delay days under 7Q 14B. 2285 2285.
No, that is okay.
So this is for the purpose, my lord. Here they are computing, my lord. But anyway, these are the, my lord. They are computing, my lord, taking into consideration when the my lord contribution for a particular wage month or period was deposited, and how much days delay had occurred.
No. See, we can understand. We are not going into that question, Mr. Sen.
Lordship.
Perhaps, like the submission of the respondent is that even if we decide to interfere with the impugn order here,
Lordship.
their liberty under 7A should remain so far as 1997 is concerned.
My lord, my lord, that is not an issue before this court. The only issue before
No.
this court, the 14.
That is okay.
14B
You say that is not an issue, but
That is not an issue,
that is what has been prayed for by them,
Oh, my lord, my humble
and
submission.
that is what has made this court confused.
My lord, that should not be a prayer, my lord.
Because this court basically does not have a basic idea about.
My lord, otherwise also, as I pointed out, any proceeding under 7A after this 20 years, lordship will kindly look into 7C. That means you have not collected this amount as escape. Can you initiate it now, my
This
lord?
is not an escape amount, Lordship. This
This
is
is
not
not-
an escape amount, Lordship. Had this been this is under determination of the.
No, what else it is, my lord, under
I
7A?
think my learned senior counsel is confusing more. That this is not an escape amount. Had it been escape amount, under 7A it would not been deposited, Lordship. It is not an escape
Amount 7A, it is deposited, then why, my lord, under 7A
Lordship,
again?
7A, it is deposited when the 7A, it is under 7A, this amount is deposited by them, Lordship. It is already deposited by them, Lordship.
See, why to make the thing very complicated? Let us see what the document says. You see, if you come to page 72, just see at the top,
Lordship,
Annexure A,
Lordship.
then Employees Provident Fund Organization statement showing amounts payable under 7Q and 14B.
Lordship.
We will not go and do not want to go behind it. Beyond it, say like that is, we take it as a statement under 7Q 14B. Now we take into consideration that year which were covered by the earlier round of litigation. From 1997 till 2001. Because earlier round of litigation was from 1998 till 2001.
88.
So whatever is beyond 2001, you take steps. But then so far as 97 and all those things, no liberty.
Lordship,
What is the
Lordship,
question of liberty?
Lordship.
See, this
the-
will make the
under-
things, but thing will make, see, like court is trying to understand the basic thing. But then it seems after hearing you, the court has become more confused.
No, Lordship, this is under 7A, Lordship. Lordship, the amount is under A7.
How do you say on the top it is written statement amount
Yes,
payable
Lordship,
under
Lordship.
7Q and 14B?
Lordship, for a simple example, Lordship, I am to make more simple, Lordship. The employees, suppose there are 20 employees, Lordship. Their accumulated money is for around 4 lakhs rupees. Accumulated money is 4 lakhs rupees. Now, Lordship, they deposited, suppose 100 rupees. For the wage month, it is covered, so to say. They are saying that for the wage month, I have deposited 100 rupees. But whether it is actually the deposit, Lordship, no, because it is under, they have deposited under 14B7Q, Lordship. It is not this is their deposits. It is not that we have deposited.
Make it simpler. This court has not understood what you are trying
Lordship, suppose, Lordship, the amount under 7A we have assessed, this is the amount, Lordship. So they are supposed to deposit the amount to our account, that this is the amount under 7A to be assessed, and subsequently the order is passed 1st January 2004.
No, just give us an example where you are referring to the materials on record. You see,
So
we are
now,
trying to.
now suppose for the wage month, Lordship, for any of the wage month, this is 97 to be paid in 2004, for any of the wage month, be it matter, Lordship. They deposited 100 rupees, so to say, for covering all the 20 employees. Whether that is the actual, Lordship, that is the actual payment, Lordship.
No, they will
Lordship,
pay
it is
the
not
amount which
actual.
you have determined. What is the question of paying?
Because it is the employers, they themselves deposit first. We don't, every month we don't determine.
Okay, whenever you determine, after you make a demand, they will pay that amount.
After every interval, when we raise the demand, suppose we ask them that how many employees, because when the employees provident fund is deposited for there might be resignation of the employees, there might be rejoining of the employees also. So it is they themselves, they has to inform the authority that yes, this many employees has resigned. Every time it is not possible for us every month that how many employees.
We can
has
understand that why you are going
But-
into all those things. We do not want to go into all
No,
those
but
questions.
this amount
What you are
pertains
trying
to
to explain-
7A, Lordship. This amount pertains to 7A and not of wage month. The 7Q 14B is
do
for
not know,
wage
but then
month.
see, you see, this is what is shown. Your own notification is saying so. So why should
Yes,
we go
because
beyond
this
that?
is deposited as a wage month. This amount is deposited as a wage month.
That
Just
is okay.
to
You see, like in such a case, you should have earlier. You should have challenged that order of the High Court.
a High Court order, it is under 14B 7Q. 7A has not been challenged, so we did not.
So this is annexure. This notice also is 7Q, so 14.
7Q 14B because they have deposited it as a
Oh.
wage month.
So same thing. If you say that 7Q 14B will take care of these things, and earlier round of litigation also same thing.
No, Lordship, this is not a wage month. Wage month 7Q 14B is for wage month period, Lordship. This is 7Q 14B is for wage month, not under 7A provisions, Lordship. Wage month is different than 7A assessment, Lordship.
Do not know what
Because
you are.
they have deposited as a wage month, Lordship.
One thing, Lordship, if you can point
Lordship,
out.
as a wage month, if they are depositing as a wage month, Lordship, then how we will know that they are depositing as a wage month?
So similar, the same situation was there in the earlier round of litigation.
Earlier
So
round
same-
of litigation, this has not come, Lordship. The earlier round of litigation, the notice which were the annexure A of earlier round of litigation, this amount has never come.
Hey, my lord,
because it-
small thing, if I can point out, Your Lordship. Now, my learned friend, I am unable to understand here what she is saying. Now, Your Lordship, on the basis of this material shock cause, our reply, our participation, authority has passed an order, which is under challenge. Lordship, I will kindly, my lord, go through that order. Is there any whisper about what my learned friend is submitting? There is not a whisper about all these things. She has built up something which is not part of the records. Will my lord go into it? I'll take the pen, my lord. It's 3 page. I'll just go through it, which is under challenge.
It's not required, Mr. Sanu. You also do not want to probably
I don't know,
kept.
where from
confused
this
by
submission
daily
comes here?
orders are there,
Even I don't
Lordship.
know what is these figures and
See,
other.
madam, this is what this earlier round of litigation. Come to page 63. See the tabulation attached therein, and just see. We'll not go. We'll go by what the document says. We'll not go by what you are saying. Come to page 63. Come to the tabulation.
Lordship.
See 7Q this amount, 14B this amount, and period is 388 to 6 2001.
Lordship.
That is enough. Good enough.
Lordship.
What more is needed?
Lordship. My
The same
daily
thing
order.
here. See, come to page 72. Same thing on the top. It is this amount. Statement showing amount payable under 7Q14. So you are trying to incorporate something which is not provided here.
Lordship, my daily order, Lordship, page number 76, Lordship. My daily order is there, Lordship. Page number 76, Lordship, my daily order.
Yes.
76.
What is this daily order? Yes.
Daily order means like when the proceeding is drawn, Lordship, the daily orders are passed, Lordship. These are the main contentions.
This is 7 order for the period from March 80 to 1997.
No,
we are
Lordship.
not at all concerned with this.
No, Lordship, this is for
Your
the
daily order, just see, after that, what it say? 7 order for the period March 1980 to October 1997.
Lordship.
Yes.
Lordship, this is 7A order. This is daily order, which based on which the entire my final order is passed. This is the daily order, Lordship. So
that is of October 1997.
October 1997,
So
Lordship.
what we are not at all concerned.
No,
with this now.
Lordship. This, see, Lordship, on going through the submissions, be it the previous damage dues calculations, Honorable High Court judgment, the challan submitted and the letter forwarded to the office informing regarding the deposits of remaining 7A dues assessed, the 7A order and the current damage dues calculations are here are the
You are
findings
reading,
of the
you are reading
undersigned.
which part? Which part you are reading?
Para 3, Lordship.
Para 3 of
Daily order, Lordship. Page number 76.
page 76. There is no para 3. The para number 1 and 2 number. If you go by the numbers.
Page 76.
Okay, it is before numbering starts.
Yes, Lordship. Before numbering starts.
Yes.
Just on going through the submissions, be it the previous damage dues calculations, the Honorable High Court judgment, the challan submitted and the letter forwarding to the office informing regarding the deposits of the remaining 7A dues assessed, the 7A order and the current damage dues calculations here are the findings of the undersigned. These are the findings, Lordship.
No, but then these are what? What is the remaining 7 uses? What do you mean by that?
7A order is passed and the 7A first assessed, 7A order is passed, then 7A is deposited.
What do you mean by remaining? Means after the High Court's order, whatever they have deposited, you say thereafter something remained.
No, the deposits of the remaining 7A due assessed. So now when the remaining 7A dues assessed means first they deposited that 4 lakhs rupees, 44 lakhs, 4 lakhs 40,000. The first they have deposited, then they deposited this 6 lakhs. So it has come to total, Lordship. That is why remaining, Lordship. It is their deposits,
No,
Lordship.
after this High Court's order covering this period, what is the question of anything remaining?
Covering, there is...
See, at that litigation, you assess some amount which after deliberation High Court reduce it and thereafter that amount was paid, everything is cleared. Where is the question of anything remaining?
7A,
Where is the question of yourself reopening and reassessing payment for that period of time?
Lordship, it is a 7A assessment, Lordship. It is not 14B 7Q,
So
Lordship.
if there is 7A, if
Seven-
earlier it was not a 7A assessment, then how 7Q came?
7A assessment, it is a 7A assessment, Lordship. 7A can be assessed. We have already assessed 7A prior to High Court. We have already assessed 7A prior to High Court, Lordship. When the High Court gave them the direction to deposit the 7A amount, then they deposited this 4 lakhs rupees, Lordship.
Now that means your 7A claim now will be free of any interest.
Lordship.
Is it something like that is to be seen like that way? Because 7Q and 14B has been paid.
7Q 14B paid. Yes.
Yes, we are just class. We do not know. This is this.
7A.
No. We do not know.
Okay, Lordship.
This after that High Court order earlier is concerned. So far as claim in relation to 1988 till 2001, be it the principal amount or the interest or damage, everything is closed.
I have annexed all the documents, everything.
No. Is it that?
Everything.
This is the meaning, isn't
Everything.
it? Now, without determining the principal amount,
Cannot be.
the interest and damages cannot be charged.
Cannot be determined.
Now, if you have to go by her submission, that means the remaining 7A, that means the remaining the dues, so far as the contribution is concerned, some part is remaining. But then, so far as the interest and damage is concerned, you have paid it by virtue of the earlier court's order. Can it be something like that?
Can't be. Lordship, that's why I'm saying, if your Lordship, I take little pain, we are concerned with the final order of the authority. Now, what is the final order? There is not a whisper about what my learned friend is submitting.
No, madam, it seems either you are not clear,
Lordship will come.
or maybe you are trying to take the court to somewhere else.
Lordship, page number, judgment of page number 66, Lordship. I am very...
See, you have referred it to many times. We have
Lordship,
given you enough
judgment-
time. Now, this court will pass what?
Lordship,
It's not
the
possible.
judgment is page number 66, Lordship. The 7A assessment is there, Lordship. Regarding the judgment, in the judgment itself, it is there,
Yes.
there, Lordship.
Where is that?
Page number 66, Lordship.
Yes.
Wide letter dated,
Which part you were reading? Just point out that.
Lordship, from the page number 66, from the beginning
Yes,
only.
yes.
Wide letter dated 28/04/1998 in the month of October 2002. The respondent number 3, however, initiated a proceeding against the petitioner under section 7A of the Act to ascertain as to whether all the dues has been paid. In the course of inquiry, the petitioner explained the circumstances under which provident fund amounts were deposited in the Allahabad Bank. Apparently,
Dissatisfied
dissatisfied with the explanation given by the petitioner. Respondent number 3, wide letter dated 1/1/2004, directed the petitioner to deposit sum of rupees this much, being the balance due under various account within 15 days from the date of receipt of this order. The petitioner duly deposited the aforesaid amount, white challan, and also intimated the same to the respondent number 3. Wide her letter dated this. The respondent number 3, however, issued notice dated this under section 7B 14Q. So now they have deposited 6 lakhs 1.
We are not going into the amount.
7.
You see what you are trying to say. It's all right. There is a demand under 7A. Yes, they paid it. They intimated you. After getting the intimation, you said, however, the amount of interest and damage were not paid, and that is how the earlier litigation came. And that is how it is decided. Enough. Good enough. Where you are taking, either you are confused and what you are trying to do, we do not know.
Lordship, my lord, only small thing, your Lordship. Lordship will satisfy this order, my lord, recommending the other period, my lord, which is not covered. My lord, they are at liberty, what your lord. Only that I should get fair opportunity.
Not remand anything, Mr. Sen. We will just give them the liberty to things.
My lord, I will get the fair opportunity, my lord, to participate. Normally it follows from the statute.
See, whatever statute says, that will be given.
Follows, my lord.
Opportunities provided in the statute, you do not
There
need
is
any
a
order
delay,
from the court.
but normally delay is not fatal,
See,
but even
but then-
then delay also I can take up.
The thing is that you see, like the clarity which the court had at the beginning
Lot of
of the
confusions.
proceeding, that stood diluted now.
I understand.
Now that is what the problem is. And we will just try to pass the order.
we are
here.
confined to
We'll
that.
We'll
If
pass
your
the
lordship-
order here. We'll try to pass the order here. If there is any mistake, just correct
My
us. Yes. We'll try to pass a short order, not a long one. Yes. Heard, London Council, for the petitioner. Yes, madam, sit down, sit down. Then paragraph. London Council for the parties. Then paragraph by this writ petition. The petitioner. There is only one petitioner.
Yes, madam.
Petitioner has sought for interference with the impugned summon dated 15/12/2021 within bracket you write 2/12/2022, issued by the Assistant Regional Provident Fund Commissioner, comma, Sub Dash Regional Office, Shillong, and impugn. There are two orders challenged under this thing here, Mister.
One. Final order.
What is the 31/10/2022 and 2/11/2022? See, come to your prayer. That's page 19.
That is the notice. Not wrong. That is the notice. 15/12, my lord. That is the notice. 2 dates.
And thereafter, come proceed, come below. Read the. What is the 31/10 and 2/11?
22.
And then what is 31/10?
Regional office by order dated. Oh, my lords, that is an order, my lord, rejecting my lordship. I'm just coming 1 second, my lord. Rejecting my application, my lord, where I have said this is covered by High Court.
Okay, so you filed a representation after the SS seat. You filed a representation to
No,
them.
no, after SS. During the proceeding, I say, how can you reopen? I filed a formal application. You cannot reopen. So for this part, High Court has covered.
So they rejected it.
They rejected.
But then that two rejections by two different. By two different orders.
One, yes, two, both.
Okay,
In the
so you-
final
so both
order
are-
also, they have said all this.
So both the orders are under challenge now.
Both are under.
Yes. And the impugn orders, right, dated 31/10/2022 and 12/11/2022, passed by the Regional Provident Fund Commissioner, dash Roman 2, the bill, the respondent number 4, comma, respondent number 4, stop. You will get it in the prayer thing, page 19 of the expedition, just see if there is anything. Okay, just what is we said? Just where you concluded, just what is it? Yes, by this. Issued by so and so, and the order dated so and so, issued by so and so. For payment of damages and interest under section 7Q and 14B of the Employees Provident Funds and Miscellaneous Provisions Act 1952. Stop, give a paragraph. Where is that order? The order, impugn order is at page?
Impugn order, my lord, the main order is at page 84.
84.
84.
And what is the amount, total amount?
Total amount, my lord, it comes to 6,64,090.
Where is that amount is quoted here? Yes. No, what is this page 86? Is this the amount?
Yes,
no.
my lord. Page 86, my lord. On the right hand side, your lordship, in the bottom.
Yes.
After calculating the total of damage and interest.
Yes. 16,64,090. Is it 16,64,090?
Yes, Lordship, 16 lakhs.
No, 16 lakhs, my lord. I'm
There
sorry.
is no dispute at least with regard to
16,
that.
16 lakhs, my lord. I'm sorry.
Okay. What? Give a paragraph. By the please sit down. Please sit down. Please by the impugned notice and order, comma, a sum of rupees 1 lakh. Oh, sorry, 16 lakh. 16 lakh 64,090 1664090.00. Okay. This you will get it at page 86 at the bottom if you want to see. Just mark it by blue. Okay? What we said? Was sought to be realized for the petitioner, from the petitioner, for delayed payment of his contribution. The notice is shown to be for the period of just a minute, just say the amounts ought to be, you have to, do not say notice, the amounts ought to be recovered is shown to be for the period of 10/1997 to 04/2007. Stop. Paragraph. Mr. Shen, Learned Counsel, for the petitioner. Primarily contents that by the impugned notice and order a demand for payment is made for the period which included the period for which the petitioner has already cleared all his dues. Stop. The Learned Counsel has drawn attention of this court to a demand notice dated 29/4/2025 and pointed out that the demand made therein was for the period from 3/88 to 6/2001. It means March 2018 to June 2021. He further has referred to the order dated 12/8/2008 passed in WPC number 160/2005 by the erstwhile Shillong bench of Guwahati High Court. Wherein the High Court had directed for payment of certain sum as final amount of claim for the entire period for which the notice dated 29/4/2005 was issued. Stop. It is submitted that in pursuant to the order of the High Court, the petitioner has cleared all his dues. The learned counsel, after full stop, the learned counsel for the petitioner contends that since the present notice, since the impugned notice in the demand order seeks to realize the amount which the petitioner has paid, the orders cannot be sustained in law. Stop. Give paragraph. Just same as P. Bhattacharya, learned counsel appearing for the respondent. On the other side, submits that the impugned notice and demand is not only confined to the years which are covered by the order dated 12/8/2008 of the High Court, but also for period which are beyond the period mentioned there. Stop. The learned counsel further submits that the demand made in the present case is with regard to the amount which are not covered by the earlier notice dated 29/4/2005 and High Court's order dated 12/8/2008. Stop. The learned counsel, however, fairly submits that in the event this court interferes with the impugned notice and the orders, liberty shall be given to the respondent to issue fresh demand notice with regard to the periods which are not covered by the order dated 12/8/2008. Stop. Give a paragraph. On consideration of the submission made by the learned counsels and on perusal of materials on record, it transpires that pursuant to the order dated just as it transpired, just say it transpired that the High Court just say pursuant to the issuance of notice dated 29/4/2025 which was 25, do not say which was 25 with regard to the claim under section 7Q and 14B of that Act, Employees Provident Fund so and so Act, comma, this the eastward Shillong bench of Gauhati High Court in writ petition number WPC number 160/2005 by order dated 12/8/2008 that passed an order for reduction of the amount demanded by the impugn notice dated 19/4/2025 and made for and order for payment of and order for one-time payment of a fixed amount together with interest therein within a period of 3 months from the date of the order. Stop. Where is your payment, Mr. Sen? Earlier, pursuant to the earlier order.
Yes. Lordship, immediately after the judgment, the challan, Annexure E, page 16,
Yes.
and thereafter the intimation also. Next letter 69 is the intimation.
Yes, all right. Yes. The petitioner thereafter has also paid the entire amount in terms of the direction dated 12/8/2008. Your order is wrongly quoted in your communication.
Sorry.
It is 19, it's written here. It's 12/8, it should be.
Yes, yes. Sorry.
Yes, yes. All right. There is no dispute. After worship, there is also no dispute to the fact that the petitioner had already cleared the amount as per direction of the High Court. Step. Well, since it is clear from the materials on record that after full stop, just after full stop, just since it is clear that from the materials on record that the respondents have finally assessed the payment of damage and interest. Oh, just a minute, just what you said? Just see the last. Since it is clear. Okay. Since it is clear from the materials of record that the amount of damages for the period, damages and interest under section 7Q and 14B of the Act of 1952 has already been paid by the petitioner, the respondent could not have reassessed the amount and made a fresh claim. Makes a fresh assessment of amount of damage and interest. The perusal of the impugn order and impugn summon and the order show that the same year made from a period of 1/4/1996 to 31/3/2014. Clearly showing thereby the period till the period till 6/2001. What is it? Showing clear. Just say. the period till 6/2021. Has been included. Therein. Stop. The amount for which the petitioner has been assessed once and paid, and was for which the petitioner was assessed once and was paid, comma, the same could not have been demanded for the petitioner. Once the matter stood settled, the intervention in pursuant to a judicial order, not intervention, pursuant to the judicial order, the action of the respondents in reopening or reassessing interest and damages for the period of 10/1/1997 to 7/1/2000 was impermissible, was not permissible. And paragraph, in view of the above, the impugned order, impugned summon dated someone dated, this number you have not quoted in your petition, Mr. Sir. Memo numbers and all are not quoted. Where is that? Someone is at
70, annexure 10.
page 70. Huh? He quote that number, impugned summon number. I have underlined to review these things. Okay, it's 15/12/2021. Within bracket, you will write 2/12/2021. And orders. Where are these orders?
Orders, my lord, there are two orders I have seen. One order is at page 82, my lord, annexure 14. And other the main final assessment order at page 84.
Page 80.
4, final assessment order.
Just a minute. So, which are the orders to be? The one is at page.
One is at page 82, my lord. That is 31/10/22, where they have rejected my prayer for reopening.
Okay. Orders dated 31/10/2022. There is nothing. No number is there, isn't it? And
my lord, the final assessment order started at page 84. Date is mentioned at page
211. And 211 are hereby set aside as cost. Stop. However, respondent will be at liberty to issue fresh demand with respect to the periods which are not covered by the order dated 12/8/2008 of the High Court. If permissible, in accordance with law. Stop. This petition stands disposed of in the aforesaid terms. No order is to cost.
Only one small thing, Your Lordship. I don't know, I could not hear properly. The assessment period, my lord, in the impugned notice issued at my lord, has been mentioned as 1/4/96 to 31/3/2014. But actually, subsequently, they have corrected, which assessment period is 10/97 to 4/2007.
It is all right. We have said like for the years we just know these things, and there will be some correction because there are some repetition of things and all.
Yes, ma'am. Obligement.
So more or less it will be more or less like that only.
Obligement.
There is a miscase also. Okay, there it is. Miscase will stand disposed of. There is a miscase also. Yes. Sridhi, you type it. If there any confusion remains, if there any, I will clarify in the chamber. Come with the file. Yes.
Item 13.
My lord, this case pertains to this 304 conviction under section 304 IPC. The matter that happened in Molonghat, there was a group fight, and one of the victims succumbed to his injury. And
Parking related issues.
yes, parking fee related issues, my lord. Today, Mr. Gurung just informed me that he has asked somebody to take time because he's not keeping well. So without him, we can't proceed as well. Next week, maybe, my lord.
Yes, all right, it's all right. You do, just if you prepare a small written
My lord,
notes
I
of your argument.
have prepared, my
Because
lord.
once we
Yes.
hear in piecemeal, the court
Yes,
tends
yes,
to forget.
my lord. So in this Lois Dotodong, there are two appeals, my lord. Lois Dotodong, I've completed my submissions, and I was just supposed to pass on the notes of my.
Other
summary
one
of
is
my
there on the list today also.
Yes, yes. The other one is, my lord, only one question that would defer, my lord. The only question, and that will go to the root also, my lord, whether TIP, whether TIP is can TIP be the sole ground for conviction? That will be the issue, my lord.
There's a conviction solely on the basis of TIP.
Yes, my lord. Because TIP is not a substantive evidence. It is only for corroboration. If there is no corroboration, then TIP can't be. Because the IO very clearly himself stated that because the other person, one of the person was not identified in TIP, that's why we let him off. And these two were this one lawyer, Comias was identified, therefore he has been charge sheeted. That is only basis, no corroboration at all. The the star witnesses, PW1, PW9 never said anything.
What about the statement of the? Oh, this is a case of. Sorry.
Yes, PW9.
There is no eyewitnesses.
There is, of course, purportedly there was an eyewitnesses. They try to say that it's a ocular witnesses, but when we read the statement, it does not even qualify to be
So,
called.
except for that TIP,
yes,
there is no other evidence connecting you with the commission of crime.
Exactly, my lord. That is the only point. Therefore, the question will rise for the Comias that whether the sole the ground can the TIP can be the sole ground of conviction. In my humble submission, it cannot be.
Yes, normally that is what the law is.
Yes.
That is what the law is.
Yes.
But then we have to see if there is any direct evidence. If there is any substantive evidence.
Yes, my lord. Yes.
And you see, like your TIP supports it, then on.
Yes, exactly, my lord. Yes. So let us take it next week, my lord.
Okay, we will see. Then that will be all right for you next week.
Sir Gurung is appearing.
Mr. Gurung is appearing. Yes. Whoever it is. Now, right now, today you are here.
Yes.
You are representing the state.
One.
So Mr. Gurung's responsibility is with you.
Lordship.
Okay. Just prepare meet on behalf of Mr. R. Gurung. Learned GA appearing for the state respondents. Not objected to by Mr. P. Yovin. Learned counsel was the appellant. This is matter after 1 week.
I'm not taking adjournment. They're taking adjournment.
I said not object.
Oh, I thought. Sorry.
We said they are prayed by for them, not objected to by you.
Okay. Obliged. The next item also.
Same order. Same order.
Obliged.
20.
Yes, Lordship. Lordship, my seniors on his legs, Lordship, in the other court, if this matter may be taken up at the end of the talk.
Even senior leading this case, keep police, it's still on his legs.
So this is a chance for you to do the case, both of you. What is to be done?
End of the board, Lordship.
End of the board, Lordship.
End of the board. Okay, then it will be second half. In first half, it will not be possible. You see, like probably.
Second.
Whether both the parties are ready for hearing.
Yes, Lordship.
And the district council?
I am for this council.
You are for the district council. Then who is your senior?
Mr. Titi Dingdo.
Okay, at the end of the board. Yes.
My apologies.
Prayer has been made for taking up the matter at the end of the board.
My lords,
because of the
senior Mr.
You are ready
also,
otherwise.
We are ready, my lords. So on a very limited issue now, because my lords, as has been already held by this honorable court and some other matters also, that a single member, my lord, cannot pass any orders. the judgments, my lords, we have copies of that. I don't think the district council is disputing that also.
You share the judgment with them.
My lords, we've already done that. End of the board, my lords.
That is what they want. It's up to whatever you want. Yes.
22.
These matters pertaining to MCS officers.
This is refused by other two courts.
Yes, my lord. Because
Very sensitive issue.
No, my lord. Because one court, the relative of that court was would be an affected party. The other court also had some personal difficulties.
Yes.
The time is a little short today. If lordship allows, I can start.
It's up to you. See, it is whatever you decide. There is no problem.
Very well.
If you want that should be taken up today, it's okay. If you want it to go to other day also, if there is no objection, then that
Maybe
also can.
tomorrow, if that is convenient.
No, if we goes, then it will go after the week. We will not
after a week, my lord.
If you at all want it. Yes, Mr. Shulai.
Lordship, I have no objection or problem.
So you can have it after a week, 1 week. All right. Okay. Yes. On the request made on behalf of the petitioner, this is a matter after a week.
Lordship.
Oh, this will the item number. How many items are there?
This is
10
22
items.
to 31, your Lordship.
Okay. After a week.
Lord,
Yes,
apply, your Lordship.
31? Sorry, 33?
May I please, Your Lordship? Your Lordship, this matter is pertaining to Section 528 of the SSR Act, Your Lordship. Your Lordship, I humbly pray, Your Lordship, that because there is a family settlement, so I humbly pray, Your Lordship, to kindly allow me to file an affidavit to bring on record the additional documents.
What for additional documents are needed?
The family settlement, the deed of settlement, Your Lordship.
Family deed of settlement.
Yes, Your Lordship.
Now, what is the matter involved here?
It's a motor vehicle accident, my lord.
Yes.
Where the billion had to expire, and based on the submissions, like on the section statement before the trial court, they had come before this honorable court to quash. But then there's no settlement deed executed between the family members and the accused. So, for that reason, my lord, they had to ask for.
So, basing on the statement made before the trial court,
Lordship.
they have asked for quashing.
Lordship.
And now you have entered into a settlement also.
Yes, Your Lordship. Since before, Your Lordship, but it is a verbal settlement, so Your Lordship, now the family members, they want to bring on record the deed of family settlement.
This is 304A.
Lordship,
Yes.
304.
And compromised by whom?
By the family members. Your
Family
Lordship.
members,
The
if it's a family
mothers,
members.
the mothers, the brother, the mother,
The
the
person
brother.
who died
Yes.
was single, unmarried.
Lordship,
Yes,
He did not have his own family. So now the settlement is entered into by the mother of the.
Mother. Because they had immediately after the funeral of the deceased, they had a family meeting, Your Lordship. So they had settled the matter.
See, go through. Probably there are some. Is there any order passed by this court with the?
Lordship, there is, my lord, where they had
That is basing on
my
the
lord, compromise.
decision of the coordinate.
Coordinate bench, my lord.
See, normally, this is a. That matter also, there was some reservation on the part of this court. But then since there exists a decision of the coordinate bench, so normally subsequent bench also will go by that. It's the decision of the coordinated bench. Now there will be, I think, please find out that order which has been passed by this court in the earlier round of litigation.
Okay,
Probably
Lordship,
in
I'll try to find out.
that is involving a matter 304. There are also some, and that is basing on the decision passed by coordinated bench. See the other bench. Try to get those all things and then bring your thing also. We'll just allow them this thing.
Lordship.
The learned counsel for the petitioner submits that. That a compromise did. It is written agreement.
Yes.
Compromise
My
did.
lord, if I may, there's a criminal petitions number 63 of 24 with Sterling Maori.
After this
From this
court decision.
Lordship.
Anyway, Mr. Ranger, just place it on the day of the thing.
Lordship.
Any objection by the state here? In this
No, my
matter?
lord, because since
You're not objecting. No, the problem is that you see, like the whatever order we pass, it becomes a precedence.
Sure.
And well, sometimes compromises are genuinely attained, and sometimes not. So we do not know what happens because like the villagers, those who are not very educated, can be influenced very, very fast.
Very true.
Okay, so sometimes minimum thing can lure them.
Well, yes, since they are family members and just to avoid all those.
Anyway, that's okay. Anyway, the Learned Counsel petitioner submits that compromise stroke settlement arrived into between the petitioner, no? Between the petitioner, compromise between the petitioner. Why there are two petitioners?
Your Lordship is a joint petition.
Who is petitioner
Your
number one?
Lordship.
The
Petitioner
accused.
number one, yes, is the
And then who is
accused,
petitioner
and
number two?
Petitioner number two is the complainant, Your Lordship.
Why they are represented by same counsel? You should
Because
not.
they have already.
See,
verbally
normally it should not be the
settled,
thing. In a
Your Lordship, so they
compromise thing,
come, together,
in a compromise thing, they're very, very difficult to determine whether a compromise has been really attained or not. Anyway, what is it? The Learned Counsel petition submits that between the petitioner number and petitioner 2 in the present matter requires to be brought into the records of this court by filing an additional affidavit by way of an additional affidavit before the matter is taken up for final adjudication. Step. The learned GA has no objection to the prayer made. Then there's a prayer allowed. How long will it take?
2 weeks, Your Lordship.
This matter. The petitioner may. The petitioner may file the requisite. Petitioner may file the additional affidavit within a period of 2 weeks. List thereafter. Yes.
Team leave.
Thank you, Your Lordship.
Second call, item number 20.
It's the issue that is now crystallized in the form of orders passed by this Honorable Court, Malaj, has just placed two judgments. Is that, Malaj, under Rule 31, one sign any orders passed by the District Council. I'll just place this. Court master.
Who is for District Council? You are? No, you are.
The Dingdo is there, man.
He's on his legs, actually. He's on legs.
The other courtroom number 2.
Yes. These are decisions by this court.
Malaj.
Yes. What does it say, Mr. Paul?
Malaj, it has to be signed by 2 and more members, Malaj.
Where do we get it?
Well, it's, if my lords kindly have, my lords have that loving stone.
Yes, yes, yes. Well, that's Lavington, the district council did not disagree.
It's the submission of the district council.
Yes, yes.
It's on consent. Because the law requires, my lords, that at least 2 members should be signing.
Yes, do you, if they have the same stand, then...
Well, it's in the impugned order passed in this matter.
So far is the Dondor Jana is concerned, where do we find it? Where is the...
Give me the copy of the Dondor Jana.
There is also similar kind of...
Same, my lords, that is the same finding.
Okay, so then what is to be done? If that is the stand, then without going into the merits, we can...
My lords, the matter can be disposed of, because in the impugned order passed in this matter, my lords, if I may just take your lordships. Lordships would find it at page 201.
Yes.
Well, it's signed by one single member, my lords. This is the deputy CEO who had signed these orders.
Okay. So this is not the communication, it is the... Okay.
This is the order, my lords.
Yes, Mr. Nangburi is there also.
Your Lordship, I appear for respondent number 6 and 7.
Yes. And the order passed in your case was placed before this, has been placed before this court. So you cannot dispute it, isn't it?
Your Lordship.
Okay, so this is also after the coming of the new act into force.
My lords.
That is what the requirement.
My lords.
Yes.
Yes, Mother. All in fact, a series of cases.
So this also will go on the basis of this.
This will have to go.
Okay, then we will not go into the merits.
Yes, no, not required.
Yes, just say, is there one hard?
Show me that relevant portion.
Just say hard, Mr. Capel, on it, senior counsel, assist by so and so for the petitioner. Why state is the party here? Oh no, state is district council affairs.
District council.
There. Okay, then record there.
State is also a party,
Mr.
number
So
one.
and so for the state. Mr. T.T. Diangdo, learned senior counsel, along with who is there with you? Yes, and you are there. You are for?
Respondent number 5.
Yes, Mr. So and so. And who is 6 and 7?
And 7 who?
Your Lordship, I appear for
Yes,
6 and 7.
so and so. Okay. Just paragraph by this writ petition. The petitioner has assailed the order dated
2/5/2024, my lords. At page 200.
2522 passed by the Deputy Executive Chief Member to KHDC until further KHDC passed by the stuck. Yes, just say. Mr. Paul, the paragraph, just say, Mr. Paul.
Just take out
At the
31.
outset, points out that the impugned order has been passed by only one executive member of the executive committee of the Khasi Hills Autonomous District Council, and in view of the mandate. Which act is this? New act is, what is the new act?
No, this will be the old act.
Old act.
That would be the facts of the.
No, new act says that two persons, isn't it?
No, even the old
Old
act.
act. Both the acts,
Yes,
says
even old.
Okay, okay.
The Khasi Hills
And,
Autonomous.
okay. Then, but then you can, we can quote that.
Yes.
What is it? Just give the name of the act.
Yes. KHADC appointment and succession of CM, Deputy CM electors and Rang Bashnong of Millennium Simshek Act
2024.
2007.
Okay, but then, okay.
Now 25 Malat.
But then you see, so far as the order placed by Mr. Paul,
Yes.
there also probably you have.
Yes, it's the same.
In the same act, my lord,
But
the
then
paragraph
here,
1, my lord.
where it has been provided here is that the new act has come into force on 11th November 2024.
Yes.
That is pertaining to maybe some.
That's
other-
Khairam. That is Khairam
Khairam
Simshek.
Okay, Khairam Simshek. Okay, just a minute. What you said? Just pointed out that the order. Only one executive committee, and which is against the mandate of law.
Section 25.
25, my lord.
Section 25 of this.
I'll be, sir.
Just say which is against the provision of
25, my lord.
25.
section 25 of
This is the.
Millennium Simshek Act
the Khasi
2007.
Hills Autonomous District Appointment and Succession of CM, Deputy CM. You see, you have to.
Your Lordship will find it at page 27 of writ petition.
Page 27 of the writ petition is there.
Is there?
Yes.
Your Lordship.
Thank you for making the thing simpler. Okay.
Twenty-five.
27. Yes.
25, no, 25 is a continuation.
Page 27.
Page 27,
Page
section 25.
Okay.
Section 25.
Now we want to know the name of the act. You
Well,
see
it's the
page
act,
20.
the name of the act, your lordship
Yes.
would find it at page 20.
Page 20. Okay. Page 20. Just check it from here. Sure. What is it? Is against the mandate of section 25. So and so act, which mandates that.
At least 2 members should be.
Which mandates that. Two or more members will be authorized to exercise power on behalf of the executive committee. Stop. He submits that, the MP in order. As such, independent order comma as such is incompetent. Stop. Mr. Paragraph just say, Mr. T.T. Dean, Learned Senior Counsel applying for the District Council does not dispute the submission advanced on behalf of the petitioner. Stop. Give paragraph in view of the above, without going with the view of the comma, without going into the merits of the case. The MP in order
25 minutes.
dated. What is that?
2/5/2024 minutes.
Is hereby set aside and quashed. Anything more?
No, let's. Highly obliged.
Leaving the executive committee to decide it afresh, no? Leaving the executive committee to decide it afresh, because it'll have to go back, no? Okay. Leaving it to the executive committee. Definitely, I think that is by virtue of the order passed in the previous order.
If this order goes, well, it's the lordships would.
Okay, leaving the
Well,
matter,
Shafi has
leaving
to
the
be
matter
heard
to
at
the leaving the matter to the executive committee to decide of the district council for reconsideration of the matter. Yes. Stop. Give a paragraph. The writ petition stands disposed of.
Highly obliged.
Obliged.
Well, there is a connected matter along with this, Millets. This is WPC number 164 of 2024.
Yes.
Well, it's based on the order which has now been set aside by your lordships, Millets. The same Milliam had suspended my sanad, which is stayed by this honorable court. So that order will also have to go.
This is
by virtue of this particular order, I have this
partly-
2-5 order, Millets.
Yes.
On the basis of 2-5, same Milliam had suspended my sanad, Millets, and that your lordships had already stayed.
Give us just
WPC number, well, it's this WPC number 164 of 2024.
Yes.
164. Listen. Causes item.
There also district council is a party.
Yes.
Okay. But then that is
the orders passed by the same Milliam.
Then what is the order here?
Well, it's my lords would kindly have a look at page 209. This is the last page of the writ petition.
Yes.
But this is
That is
dated
the English translation.
My lords.
Yes.
By this, the Dorbar Hima Milliam, after receiving the order dated 2/5/2024, which was informed by letter number so-and-so, dated 2/5/2024, duly signed by the Deputy Secretary to the Executive Committee so-and-so, hereby suspend the sanad number so-and-so.
This order dated second, which we have set aside.
It has been set aside.
Okay. Just say. Just say it is submitted by the. Just say hard. Just say it is submitted by the Learned Senior Counsel appearing for the petitioner. The order issued by the same of Imam Millim dated 20th May 2024. Which challenges this petition was passed on the basis of order dated 2nd May 2024. You do one thing. We record this memo number from this order, page number 22. Okay, was passed on the basis of the order dated 2nd May so and so by memo number so and so of the district council. Come on. It is submitted that since the order of the district council dated 2nd May so and so has been set aside. Come on. The impugn order also will not stand in the eye of law. Come on. Paragraph. You say there is no rebuttal of the submitted advance by the Learned Senior Counsel, by the council appearing for the respondents. The writ petition accordingly stands allowed. The impugned order passed by memo number so and so. Just say that also. Okay. Dated 20th May 2019. This you'll get it here at page 209. And the earlier order which we have said of district council, that is referred here, memo number. Okay. What is it? The so and so is set aside in cost. Stop.
Highly obliged.
No.
Obliged.
Properly worded.
Well.
There's no other way. Any confusion, just yes.